Sorry, Mr. Speaker. Me and gadgets don't work sometimes. Mr. Speaker, I'm pleased to speak on Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts to make consequential amendments to the other acts. This is an omnibus bill. It's over 200 pages, Mr. Speaker. It includes major reforms to our criminal justice system. With a concerning level of rural crime in my riding, the safety of my constituents is a high priority to me, and I believe the safety of Canadians should be the #1 priority of any government. While there are some aspects in this bill that I agree with, it will help to reduce delays in the court system. There are several problems associated with this bill that I have concerns with. First, I want to talk about the bill itself. As I mentioned, this is a 204-page omnibus bill. I want to remind the Liberals that during the last election, they promised they would never table omnibus bills. Yes, but they did. Here it is. But, you know, there was 80 other promises that haven't been started or broken. This is a quote that is still up on the Liberal webpage. I looked it up the other day. They state that omnibus bills, quote, prevent Parliament properly reviewing and debating the government's proposals. We will change the House of Commons standing orders to bring an end to this undemocratic practice. End of quote. That's right on their webpage. Here we are today discussing an omnibus bill. Yet, it's a mixed bag that amends a total of 13 different acts in various ways, Mr. Speaker. This bill needs to be split into more manageable portions so we can properly study it. What's more, the government also threw in 3 bills that have already been tabled, Mr. Speaker. Bill C-28, victim surcharge. Bill C-38, consecutive sentencing for human traffickers. And Bill C-39, repealing unconstitutional provisions. Perhaps this government could manage their legislative agenda a little bit more effectively. They would not need to retable these bills, push through on an omnibus bill, and repeated forced time allocation and limited debates. Mr. Speaker, the Liberals are failing to take criminal justice issues seriously. In March, they tabled this bill the day before a 2-week break period in our sitting schedule. Then they spent a half a year and returned it now when there are only a few weeks left before a 6-week break period. That doesn't give the image that justice is a high priority with the Liberal government. As you may know, Mr. Speaker, the government lack of judicial appointments have resulted in violent criminals walking away without a trial. As of November 2nd, 54 federal judicial vacancies remain. Appointing judges is an effective solution that is much faster than trying to force an omnibus bill through Parliament. And Mr. Speaker, I remember in April the minister talking about 54 more federal judges to go, and here we are, almost the end of the year, and still no action. I also want to talk about what's actually in the bill. Again, there are some parts of the bill that I can support. For example, I agree with efforts to modernize and clarify interim release provisions and provide more onerous interim release requirements for offences involving violence against intimate partners. Modernizing and simplifying interim release provisions is an important step that will assist many rural communities across the country that do not have the resources to navigate lengthy procedures and paperwork. For that reason, I support that, Mr. Speaker. However, I wish the stricter release requirements were not limited to offences involving domestic abuse. With an alarming rate of rural crime in my riding and across Canada, which is often carried out by repeat offenders, I believe we need to make it more difficult for all violent criminals to be released. Otherwise, we have a revolving door where they commit a crime, get arrested, get released, and start all over again. Mr. Speaker, I was at a rural crime seminar in the city of Red Deer last Friday, and a former police officer came forward from Calgary City Police and reported to us on one of the cases that he worked on just recently, where they charged a Alberta offender with 130 offenses ranging from B&E, car thefts, equipment thefts, possession of stolen property. At the last sitting in Alberta, the judge released him. Out the door he went. So where'd he go? He took off to BC. Now we understand that they're looking for him in British Columbia, where they have 100 similar outstanding charges in a very short period of time. This person should not have been released. These criminals prey on farmers and elderly people. They know that RCMP resources are lacking in these areas and take full advantage of this. What this government needs to do is provide our law enforcement agencies with the tools they need to stop revolving door criminals in and out of the courts, and that is happening at a constant time. Mr. Speaker, victims should be a central focus in the Canadian criminal justice system rather than a special treatment for criminals, which is why our party introduced Victims of Bill Rights, while the government, unfortunately the Liberals, don't agree, since Bill C-75 will repeal our changes to the victim surcharge and reduce the overall use and effectiveness of the victim surcharge. I believe in protecting the victims of crime, which is why I introduced my own private member's bill, Bill C-206, that would ensure that criminals who take advantage of vulnerable people, specifically adults who depend on others for their care, are subject to harsher punishments. Mr. Speaker, last month, a gentleman from my riding of Yellowhead was the witness before our Public Safety and National Security Committee. He shared with us firsthand his experience. It was a terrible story. This gentleman, who I consider a friend, is at age 83. He heard his truck start up one day when he was having lunch with his wife. He walked outside to see his truck driving out of his yard. He lives about 70 kilometers from the town of Edson, where the local police office is. He picked up his phone and was about to call when his vehicle returned to his yard. Two youths, one age 18 and one age 17, came out, knocked him to the ground, repeatedly kicked him in the face, in the chest, in the ribs. Remember now, he's 83, Mr. Speaker, and then attempted to slash his throat, then drove off again. They're still dealing with this in the courts. That's been a year, Mr. Speaker. This gentleman has had to attend court 10 times so far, and the matter is still not over. On our side of the House, we will always work to strengthen the Criminal Code of Canada and make it harder for criminals to, Mr. Speaker, I'm concerned that portions of Bill C-75 will weaken our justice system. Through the bill, the Liberals are reducing penalties for the following crimes: participating in criminal organizations, various acts of corruption, prison breach, impaired driving, abduction, human trafficking, forced marriage, and arson, just for a few of many in that bill. Participation in terrorist activities and advocating genocide were deleted from this list only because of our government, the Conservative opposition. We made amendments which was accepted by the committee. Mr. Speaker, that is just a few examples of more than hundreds of serious crimes that could be prosecuted by summary conviction and result in lighter sentencing or even fines. This government is failing to take criminal justice issues seriously. It's reducing penalties for serious crimes sends the wrong message to victims, law-abiding Canadians, and to criminals. I'm also concerned about the wording used in the section that increases maximum sentences for repeat offences involving intimate partner violence. I support increasing these sentences. However, I do not support replacing the language of spouse with intimate partner. I believe both should be in there, Mr. Speaker. 1 minute. Thank you, Mr. Speaker. I understand that not all domestic abuse is within a spousal relationship, so there is a need to have intimate partner included. However, it should not replace spouse. Rather, both terms should be introduced. Another problem I have with Bill C-75 is the reversal of protection for religious officials, Mr. Speaker. When Bill C-51 was referred to in the Standing Committee on Justice and Human Rights in January, there were two amendments from my Conservative colleagues. The first amendment kept Section 176 of the Criminal Code of Canada, while the second amendment modernized the language of this section of the code. The Liberals agreed to that, and that was good, but they need to listen more. You can imagine my disappointment when I read in Bill C-75 that Section 176 of the Criminal Code is once again under attack. Assault on officiants during a religious service is a very serious and should remain an indictable offence, Mr. Speaker. Thank you for the opportunity to present my views.
Questions and comments? The Honourable Member for Parkdale Hyde Park. So I thank the member from Yellowhead for his contribution to today's debate about Bill C-75. I'll offer one comment, two comments and one brief question. The first comment is that the term intimate partner is used in this legislation for a deliberate reason. It is a more expansive term than just simply the term spouse. Violence occurs, as we've heard in today's debate, for half of all of the women in this country, and that violence is perpetrated in couples that are married, but also in couples that are unmarried or indeed just dating. The second point is that there was an actual factual error that was mentioned in the comments by the member opposite when he indicated that a reduction in penalties has been provided for a list of offences, and he listed them. Hybridization does not ipso facto reduce a penalty. Hybridization allows a crowd to proceed by way of summary conviction or by way of an indictable proceeding. It is not a predetermination of the sentence. What I would ask the member opposite, the member from Yellowhead, is that he is convinced about the need to ensure that there need to be tougher penalties for people who are convicted of crimes. On this side of the House, we agree. That is why we're taking the summary conviction limit from 6 months, traditionally, to 2 years less a day. I would invite his comment on that provision and whether he approves of that change, increasing the penalty for summary conviction offences to 2 years less a day.
The honourable member for Yellowhead.
I'd like to thank the honourable member, Mr. Speaker, for that question. And yes, increasing that penalty is definitely one of the ways to go. But we must also ensure that if we are changing the legislation, is that our prosecutors and our court systems abide by the new regulations and follow through with that. It's no use changing these regulations if the courts will not follow them, the prosecutors will not follow them. It'll again, we'll be on the revolving door system, just as it is today. Won't change the matter much.
Questions and comments. Question et commentaire. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank the honourable member for Yellowhead, who has a great deal of knowledge about Canada's justice system, having spent a few decades as an RCMP officer. I'm glad the member brought up the victim surcharge, which is an important source of funding to support victims of crime. We on this side of the House at the Justice Committee brought forward an amendment to increase the victim surcharge by $25. It seems like a very modest amount that could go a long way to supporting victims. Yet, shockingly, Liberals over there shot it down. Would the honourable member agree that our amendment was quite reasonable and that the failure of government to support our amendment is just another example of the government putting victims last?
The honourable member for Yellowhead.
I'd like to thank the honourable member for that question, and you know, it's very appropriate. Yes, surcharges should be raised. We had a witness appear from Saskatchewan 2 weeks ago at the Justice Committee, a farmer, and he says, you know what, I really don't care if that guy goes to jail for 2 months or 6 months, but when he steals my combine and causes $100,000 damage to my combine, just driving it around the field, running it through the ditches, I should be able to sue that person, or the court should be able to place a penalty on that criminal to repay that thing. And if it takes him for the rest of his life to pay back that $100,000 damage to my combine, that would be justice. The victims in Canada are the ones that are suffering. The criminals are not suffering. We must make the criminals responsible for their actions, and that is one way we could do it. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary to the Government House Leader. A very brief question, and hopefully we'll have a very brief answer.
Very brief, Mr. Speaker, would be recognizing that the federal minister has actually worked diligently over the last couple of years, 2-3 years, with provincial counterparts, territorial counterparts, Indigenous people, and many other stakeholders, and was gone through the committee, and it is overwhelmingly perceived as good, solid legislation, something that is long overdue. And I'm wondering if my friend from across the way would at the very least recognize that many of the changes that are incorporated within this legislation is in fact something that should be put into place as soon as possible, because we have so much at stake here.
The Honourable Member for Yellowhead in 30 seconds or less, please.
Well, as I stated earlier, Mr. Speaker. I mean, this thing was originally brought to us early in the year. It was brought to us a day before we were going on a 2-day break. There was 3 sections that I mentioned, I think 38 and 39, that were previous bills that they've thrown into this one. Why weren't they done with? Why weren't they dealt with? If it's so important that they get done, why did they wait so long to do it?